Officer Dade, you want to open my courtroom, please? Officer Dade. I guess I don't have it. All right, I'll do it myself. All right, we are on the record. The 36th District Court is now in session. I'm Judge David Robbins. Let us get started with our matter of, Sweeta and Brainer are here. Brainer, admit, Sweeta, admit. Okay, unmute yourself, Mr. Sweeta.
Yes, good morning.
All right, let's get started. We are on the record. This is file number 1916870, Discover Bank versus Mary Moore. Could I have your respective appearances?
Yes, Your Honor. Attorney Jason Brainer on behalf of Plaintiff Discover Bank.
Are you a member of the State Bar of Michigan, Mr. Brainer?
Yes, Your Honor, I am.
Do you have the bar number?
P69653.
Let's let Mr. Sweeta finish drinking.
Yes, again, Your Honor, Attorney Daniel Sweeta, appearing on behalf of the defendant, P number 46591. Sorry, Your Honor, I just got a frog in my throat. Sorry, I had to get a drink of water here.
If you were in the courtroom, we'd have taken a break to let you get a drink of water.
Okay,
right?
thank you, Your Honor.
Not a big deal. Okay, guys, we were I'm kind of confused on the status here. At one time, there was a stay entered for the purpose of allowing the matter to move to arbitration. And as I understand it, for whatever reason, that did not occur. What's going on here?
If I may, very briefly, Your Honor, my client, Ms. Mary Moore, she's a senior citizen, she's retired, and she's on Social Security. So she has a very limited income. I know that's not a defense. I believe I was contacted last month by the plaintiff's attorney office. I have contacted my client again to try to get a settlement of this. So, I'm hoping to try to work out some sort of settlement with the plaintiff in light of her being beyond a fixed income Social Security.
Why didn't this matter go to arbitration if you weren't able to resolve it? It was the defendant's motion to compel arbitration.
Yes, Your Honor, she just was unable to afford the arbitration fee.
So, Your Honor, if I may, typically the plaintiff picks up the cost of arbitration. That's in the contract.
Yeah, I'm not understanding this. It is the obligation of your client, Mr. Sweeta, said she wanted arbitration. She had not yet filed a demand for arbitration. But under the contract, the plaintiff pays the cost of that arbitration. All she had to do was file the demand.
Yes, Your Honor.
So what's going on here? Are you going to go to arbitration or not?
I don't think we're going to arbitration, Your Honor.
So we wasted 75 days. Is that what it boiled down to?
Well, all I can say, Your Honor, is that my client, she's a senior citizen. It's difficult.
I'm a senior citizen.
Okay.
That's not an expense. It's true. Your client took 60 days to stay because she wanted to compel arbitration, did not do the arbitration, and now you say she doesn't want to do arbitration. Okay, good. Let's move on.
Okay. So, Your Honor, if I may at this point, on behalf of plaintiff, I think what we would just prefer to do is to get a date for our motion for summary disposition and proceed with that.
Yeah, I'm done with this. What I'm doing is this. How long will it take you to file your motion?
I believe we had already filed that motion. It was supposed to be heard on the 9th of December 2019. And then we agreed to that 60-day stay for arbitration. As you're quite aware, Your Honor, it didn't happen. And so now we're just We just need a date.
And I have a defendant's response to both of those motions, correct? So all we need is a date for hearing. Okay, so be it. Let us get you a date for your motion. We'll stop wasting any more time on this. We have pleadings filed by both of you in response to the motions, so we don't need to wait 30 days to get the matter on for hearing. How about how about December 10th? Does December 10th work for both you gentlemen for the hearing date?
That's perfect, Your Honor.
Mr. Sweeter?
Yes, that's fine. What time would that be on
It'll be 10 o'clock.
December 10th?
10 o'clock like today.
Okay,
Okay.
December 10th. This is the motion for summary disposition on behalf of our plaintiff. We'll send you gentlemen a notice. We'll get you on your way. Is there anything else we can accomplish today?
Okay. That sounds great, Your Honor. Thank you.
Anything for you, Mr. Sweeter?
no, Your Honor, you may just mail those out. I put it on my calendar, so.
All right, we'll send out a notice, December 10th, 10 o'clock, plaintiff's motion for summary disposition. Thank you, gentlemen.
Okay.
All right. Thank you very much.
Have a good Thanksgiving.
You too, gentlemen. Be safe.
Yep,
Okay.
thank you. Take care.
Hello?
Morning, Your Honor.
Who's on the call at 9,000?
So Attorney Thomas Duquette for Jefferson Capital Systems. Case
Okay.
number ending in 598.
Hold on, I have Mr. Smart here. We are on the record calling file number 2015258, Jefferson Capital System versus Kristen Smart. May I have your respective appearance?
Good morning, Your Honor. Thomas Duquette, P82958 on behalf of the plaintiff.
And what is your name, sir?
Good morning, Your Honor. My name is Tristan Smart.
All right, gentlemen, where are we on this file? This is our first pre-trial.
Yes, it looks like our office has had a chance to speak with Mr. Smart on a couple occasions here. He seems to be indicating some sort of fraud. The underlying debt here is a DTE Energy account. With all that being said, I would ask the court to open discovery and maybe we can get this resolved by the close of discovery.
All right, Mr. Smart, is it your intention to represent yourself in this matter?
Yes, sir.
Sir, you have an absolute constitutional right to do that. What you do not have is a right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that bind that attorney will bind you. Do you understand that?
I understand, sir.
Okay, so here's what we're going to do. We're going to open your written discovery. We'll give you a return date. So December 10 work for both of you?
Yes.
Yes.
All right, December 10th at 10 o'clock, December 10th at 10 o'clock, we will have our next pretrial Your written discovery is now open. Gentlemen, is there anything else we can accomplish today?
I don't believe so.
You, Mr. Smart.
Nope, everything is good on my end, sir.
Okay, then what I'm going to do is I'm going to send out a notice for our next pretrial, December 10th at 10 a.m. and the court is opening your written discovery at this time. Thank you, gentlemen, for coming in, and be safe. We'll talk to you on December the 10th.
Thank you, Your Honor. Have a good day.
You too. Be safe.
Thank you, sir. You as well.
I'm gonna go proceed. You need to unmute, Mr. Saylor. No, you're muted. Oh, okay.
I'm sorry, Judge. I was in with someone else.
Okay, are you finished that one?
Yeah, I'm all finished. Yes.
Because I don't have your other side. Now wait till 10:30. If you want to go and finish something and come back then.
I don't think she's gonna come, Judge.
Okay, well, let's call your file. You can put yours on the record.
Okay.
This is case number 18163-912. That file is entitled Anthony Willis versus Yolanda Daniels. By a notice dated October 12, 2020, this is the date and time set for the motion for summary disposition filed on behalf of defendant Yolanda Daniels. Could I have your appearance, please?
Yes, sir, Judge, and good morning. My name is Attorney Albert Sala, P83929, on behalf of defendant Yolanda Daniels.
Now, Mr. Sala, I don't have Ms. Fluker, who's the attorney for the plaintiff. You said you didn't believe she was going to appear?
I did not. I received an email from her. I'm looking at the email now. It's Friday, 1:29 p.m. She sent me an email saying that she's trying to request an adjournment for the hearing on Monday, which would be today, Judge. And she has some sort of medical circumstances and she will not be able to be released to go to work. I don't know if she tried to contact the court, but she did reach out to me and let me know about that.
Does that email give any date when she will be released to work?
No, it just says that she will keep me posted on the information, and she's anticipating a 2-week adjournment.
Would that be all right with you?
I mean, yeah, Judge, given the circumstances, medical circumstances, I would say it's okay. I would even allude that this may be something that can be determined on the briefs alone, but if
Well,
this
let me-
is oral argument,
I want to ask you this. Did you get a response to your motion for summary disposition from Ms. Fluker?
I didn't get a response. Let me double check before I make that. But I don't remember ever getting a response, Judge. No, Judge, I never got a response. Did the court receive a response?
I did not. That's why I was asking if you had.
No, I have not received a response, Judge.
All right. So your motion for summary disposition,
Did this court receive my motion? Certainly.
yeah, it was filed on or about October 13th of
Thank you.
2020.
Thank you.
And on October the 12th, because the hard copy came October 13th. A couple of days earlier, your fax copy came. And when we got your fax copy, we noticed the matter for hearing today.
Good.
So as I understood what you're telling me, you have not received a response to your motion from Ms. Fluker.
No, I have not.
And the court rule requires that if she's going to file a response, it has to be a motion for summary disposition. It has to be filed 7 days prior to the date of the hearing. Is my understanding of the law in that regard correct?
Correct, Your Honor.
And she reached out to you not 7 days, but this past weekend, that's past Friday, which would be Friday, 3 days to request an adjournment, past the time for her to have filed her written response.
Correct.
Fair to say?
Correct.
All right. Counsel, I'm prepared to move forward and decide this matter on the pleadings. This is a C10 motion. And in that C10 motion, in essence, what your claim is is that you are entitled to summary disposition because prior to the time that Ms. Fluker entered the case, you had served requests for admissions on the plaintiff, which basically boiled down to, do you admit you have no case and you have no damages? These requests for admissions were not answered, and therefore under MCR 2.312, deemed to be conclusively admitted in this matter. It appears that on August the 21st of 2020, after a response was filed on behalf of the plaintiff, this court granted your motion to deem the request to be admitted. And the motion for summary disposition, which you have filed, is based upon that. MCR 2.312 is quite clear as to the consequences of failing to respond in a timely fashion to a request for admission. The court rule provides that the matters are deemed to be admitted conclusively for the purpose of the litigation. Put another way, having failed before Ms. Fluker got into the case to timely respond to the request for admissions, the admissions include admitting that the defendant owes the plaintiff $0. That's the end of the case. Your motion for summary disposition under MCR 2.116 C10 is granted. I will note in the judgment that the plaintiff failed to appear due to a medical emergency, but she had also failed to plead prior to the time, the apparent onset of this medical emergency. If she wishes to file a motion, she certainly has a right to do that. But I don't think your client should have to continue to generate attorney fees in this matter when the guts of the case, even if she filed a answer, would not, as far as I can see, change the case. Her client, not her client has conclusively admitted that the defendant owes the plaintiff no money. That's the end of the case. Your motion for summary disposition is granted. Under MCR 2.116 C10, we'll send out a judgment. Thank you, sir, for coming in. You're off the record.
Thank you, Judge.
Have
Have a good, safe week, okay?
Be safe. We are now